Hi, my name's Christine. I'd like to share with others my experience with Mr. Davis. I have a juvenile dependency case, and Mr. Davis has gone above and beyond and has been so amazing with me and my family. He has not only been an incredible attorney, but an amazing person and friend. He has
Welcome to CPS Office Hours. I'm Attorney Vince Davis, and today's topic is a game changer: how to get your CPS case dismissed early. Yes, it's possible, but it takes strategy, persistence, and the right moves at the right time, and of course, the right lawyer. If you find this morning and this information valuable, please do me a favor. Please consider making a donation to us to help keep the production costs down. And the directions for making such a donation are right there at the bottom of the screen. Shows you how to make a donation. Okay, let me pull up my notes. Let me get to the right page. Okay, understanding what, quote, early dismissal, unquote, means. Early dismissal means getting your case closed before a full trial or at the earliest review hearing. Usually this can happen at the jurisdictional hearing before no legal findings are made. It can be done pre-disposition before your services really start. And it can be done at the 6-month or even the 12-month stage where those review hearings take place. Dismissal early can save your family months or years of struggle and hardship, especially dealing with CPS. How early dismissal happens. Here are ways cases get dismissed. Number one, there's insufficient evidence. CPS doesn't have enough proof to meet the legal standard. Number two, there have been a violation of your rights. CPS violated your constitutional rights through illegal removal with no warrant. Number three, reunification before the hearing. You can fix the alleged issues before the court dates or before the jurisdictional or dispositional hearing. And there can be a settlement agreement. You can negotiate a safe resolution before trial. Every county, every state has different requirements, and it sometimes depends upon the social worker supervisor, and of course the prosecuting attorney. And in California, that would be the county council. And in my experience, most judges don't want overloaded case calendars. If you can show stability early, the judge may be inclined to close the case faster. There are some critical early actions you must take. Here's what you should do immediately. Number one, demand discovery early. Get the CPS files, the police reports, the social worker's notes, and review them carefully with your attorney. Number two, challenge the jurisdiction of CPS and the CPS court. If CPS allegations don't fit within, in California, the Welfare and Institutions Code, Section 300, file a motion to dismiss. Yesterday on the office hours, I think I talked about such a motion. In California, it's also known as In Re Troy, Troyd motion. I think it's a 1989 case out of San Diego. You can Google it, read it, and talk to your attorney about it. Number 3, get services voluntarily. A lot of people don't want to do this because they think it's an admission of guilt, and it really isn't. Start parenting classes, therapy, or drug testing before the court orders it. It can buy you a lot of points and credibility with the court. Number 4, gather evidence. Letters, drug tests, proof of safe housing, employment stability, character letters. Now, generally in California, character evidence is not admissible. However, there is an exception. There are several exceptions in California, especially where character is at issue, quote unquote. There has been at least one very well-known evidence scholar who says that character is always at issue in juvenile dependency cases, in these CPS cases. My luck with character evidence has been about 50-50. Some judges will let it in, some judges won't. But I can tell you that every time you try to produce character evidence, the social worker's attorney is going to object to it. Be prepared for those objections and be prepared to get that character evidence into court by planning and strategizing with your attorney before the court hearing. Number 5, and number 5, this is one that's very rarely used. Request mediation. Many counties offer pretrial mediation to settle cases early. Sometimes I've been in counties where no one knew whether they had mediation services, and I would ask, and they said, "Oh yeah, we do mediation here. Nobody ever takes advantage of it, but we can do it." And sometimes those mediations turn out to be a good strategy because it's nothing like having a mediator, an independent mediator, usually a retired judge, help you try to resolve the case. In California, well, in Los Angeles County, there's actually a judge who's permanently assigned to help do mediations. So always consider mediation. All right, next, there are mistakes that you have to avoid that delay your case being dismissed. And you want to make sure that you don't make any of these mistakes. Here are a few things that can hurt your case. Number 1, you missing court hearings. It's important that you and your attorney make every court hearing. If you miss a hearing or if you're late for a hearing, sometimes that has a negative impact with the judge. Nothing may be said, but believe me, judges don't like it when you're late or that you're missing court hearings. Number 2, failing drug tests or missing services. Don't fall into that trap. Number 3, getting into new legal trouble. You know, it's interesting. Every once in a while, I have a client who has a case, catches a case with CPS or the police, and then they get into more trouble. Please stay out of trouble. People are watching you. If you catch a new case, the social worker will find out. It's all computerized. They search your name. Next, don't send angry emails, texts, or social media reports about CPS. You'd be surprised how many people do that, and almost always there's retaliation. You know, it's bad enough you have a CPS case. Don't make it worse by antagonizing the social workers. You know, my grandmother who raised me used to say, never get mad, get even. So you have to win your case, get your children back, and then if you think you were wronged, bring your civil rights case against them. Always act like the judge is watching everything you do, because often the judge and CPS, they are watching you. Getting your CPS case dismissed early is possible, but you have to be aggressive, smart, and fast. Don't wait for CPS to be quote unquote fair. They are building a case from day one. If you want the tools to fight smarter, join my Fight CPS School, SKOOL, their weekly webinars, templates, and live Q&A for just $10 a month. And if this live stream has helped you, please consider donating and supporting us. Your donations helps us, and it helps us arm more families with knowledge to win cases against CPS. Thanks for watching this morning. I'm Attorney Vince Davis. Stay prepared, stay smart, and of course, we're on every day for office hours at 6:30 a.m. Pacific Standard Time. Now, as I promised yesterday, if you have questions, please post them. Post them in the chat. We are live streaming simultaneously to 8 different platforms on social media, on YouTube and on Facebook. But when you post your question, I get to see it here right up on my screen. So let's start with a few questions before we sign off. Taylor Arnold on YouTube. Tyler says, what can I do when the first judge violated due process by no warrant and no notice of emergency hearing? Well, Tyler, depending on the circumstances, you can try to make a motion to redo the first hearing based upon lack of notice. You can sue CPS for lack of notice and violations of your due process, but you have to do that in a separate case, usually in the civil department of the civil court or in federal court. One of the things I would suggest is that when you speak to your lawyer, focus on you and your lawyer making a plan to get these children back. Don't worry about the violations of your civil rights. You being compensated for that will come in the future, but maybe not now. Okay? So don't worry about it right now. All right. Hold on a second. Let me look at. Look at the next question. Next question's from Facebook. From Twisty Dister Hendricks. Hope I pronounced that right. Oh, she says, I am not real, that I'm a fraud. I'm sorry that you feel that way. Okay, the next question is from Tyler. Tyler says, the court administrator has my offspring, so that's a conflict of interest. Yeah, that's a conflict of interest. I would suggest speaking to your lawyer, making a complaint with the Department of Health and Human Services in Washington, D.C., or the local U.S. Department of Justice Civil Rights Division. That's very interesting that a court personnel has your child. Tyler says, I have the emergency trial and the last hearing transcript showing the violations. Tyler, you got to find a lawyer that's going to help you with your civil rights issues. Okay, here's a comment from Margaret King on YouTube, a member of our YouTube channel. Good morning, Mr. Davis. Have a blessed day. You too, Margaret. Thank you very much. Ms. Bam on YouTube says, what is the court uniform? Ms. Bam, you have been watching some of my old videos. Let me describe to you guys what the court uniform is and the psychology of the court uniform. And this is actually at the top of my mind because I had this conversation with a very close friend recently who has a court case, not a CPS matter, but has a court case and is going to court. Okay, for women, Ms. Bam, the court uniform is dark blue, gray, or black pantsuit with a white blouse, preferably a white blouse with the buttons in back. Matching shoes, 2 inches high or less. It also requires you to, as a woman, wear your hair back in a single ponytail. And here's the kicker: no makeup. That's the court uniform for women. Oh, and then there's the 10-inch strand of pearls, usually cosmetic pearls, and the matching stud pearl earrings that you can buy at JCPenney or Target for like $39.95 for presentation in court. Now let me ask you guys something. When you see a person, when you first see a person, in your mind or in your subconscious mind, you make decisions about that person. Well, judges are people too, and they make decisions subconsciously based upon what you look, how you act, your body language, your facial expressions. So if you want to gauge or take advantage of all the little things psychologically and emotionally, the court uniform is definitely something that you should consider. I don't know if you guys remember a TV show called Bull, Bull. It was on CBS a few years ago. It was about a high-paid jury consultant. And things like court uniforms tend to be important psychologically on the triers of fact, the judge and the jury. So try to make take care of every advantage. The way you look when you go to court does matter. Maybe it shouldn't, but it does. So don't go to court like, you're going to the beach. Go to court like, you're going to church, or something similar. So Ms. Bam on YouTube, I hope that answers your question. It's actually a good question. Ms. Bam on YouTube, I have a video or two about the court uniform for women and men. So if you're on uniform, if you're on YouTube, you might want to try and search that. Okay, from YouTube, Kelsey Oliver says, how can I sue because they took my newborn baby from the hospital because they said I was using drugs while pregnant and they didn't have no positive test results from the baby poop? How can you sue? Okay, you can sue by getting a lawyer and having him or her evaluate it. But if you still are without your child, I would focus my energies on getting the child back into your custody. So that's one of the things that you should not take a look at, but consider and work on right now. If it hasn't been in California, if you're in California, you have 2 years to sue. So assuming that the baby was recently taken, you have enough time to sue. Worry about getting your child back. All right. All right, Margaret King on YouTube. Margaret's a channel member. There are Facebook groups where people post things. I've noticed they're not as private as one thinks they are. Oh, I'm sure they are. Everybody has their opinion. But what kills me, Margaret, is the person who might have a bad opinion about me. Why are they up at 6:30 in the morning, 7 o'clock in the morning, watching my shows, my office hours? Okay, Tyler from YouTube says, thank you. You're welcome, Tyler. Okay, well, now we got a long one. Brittany from Facebook says, if my case haven't found jurisdiction within 184 days, I had just had a court last week, and the county council requested to have it continued till May 13th because they have neglected to find any evidence, and they want to hold a juris dispo that day. They attempted to transfer my case out, but it was kicked back from what I understand, or what looks like only one of the kids were kicked back. But it's a little confusing because they stacked the cases. So 2 kids are on one and 2 kids were on another. Brittany, I don't want to say that I've never seen that before, because I have, and it's very unusual. But you should definitely be talking to your lawyer, private or court appointed, about having all the cases consolidated in one county. And I just found out something that I knew, but I didn't really consider it. I was on a case in one county, and at a certain time in the case, I made a motion to have it transferred. And the case was transferred to Los Angeles. I, of course, appeared in the Los Angeles case. They called me up one day and they said, "Oh, Mr. Davis, can you appear in such and such a case? Because we're having the transfer in hearing." And luckily I was available. They're supposed to give you 24, 48 hours notice. So I jumped online, and in the conversation in the hearing, the judge was considering not accepting the transfer in. And the reasons why the judge gave, although legal, I was very surprised. Turns out that the judge did not did accept the transfer in, so it wasn't a big deal. But sometimes transfer ins are not as automatic as one might think. All right, Margaret on YouTube. In the courtroom on the stand, should the parent be facing the counsel or facing the judge? That is a great question. The answer is both. Your audience is the judge. Your sub-audience is the counsel sitting in front of you, but the judge usually is off to your right and elevated. So when you testify, you should be testifying to both, in my humble opinion. You should be answering the question straight ahead to the person who's asking you, and during that answer, sometimes you glance over, you speak to the judge, blah, 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 blah. You go back, blah, 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 blah. You get it? Include the judge in everything, but not exclusively. The judge is there. He or she is making the decision. So include that person in your quote unquote testimony, your conversation in the court. Margaret, I hope that answers your question. I'll tell you a quick story of a trial that I did. It's been some years, and it wasn't a CPS case, it was a probate case. And the setup was counsel in front of the witness, judge over here on the right-hand side of the witness. And I purposely stood up and walked across the room where I stood right next to the wall. And that caused the witness to turn and face me. And as we continued with the questioning, she got comfortable and kind of adjusted her seat to basically face me. And all the judge saw during the entire examination of the most important witness in their case against my client, the witness had her head and her back shoulder to the judge. Now, what do you think about people that talk to you and turn away from you? Right. You get a little annoyed. Subconsciously, you might think that they're not telling the truth. Right? Well, at the end of that hearing, that trial, the judge found that witness was not credible. Now, there were a lot of reasons why you could find that she was not credible in my cross-examination, but one of the reasons I think was she had her back of her head and her body turned away from the judge. She didn't include the judge in the conversation. And the judge would, these are non-jury trials. The judge is the most important person in the room. So consider that if you're ever on the witness stand. Okay. You may want to talk to your attorney about it. I'm not sure a lot of attorneys even think about those things. The only reason why I think about it is because, I was trained to. I went to the Jerry Spence, GERRYSPENCE, Google that name, the Jerry Spence Trial Lawyers College. Okay. Let me find out. Okay, Ms. Bam from YouTube, how can people access the money found available for child sexually abused by foster parents? Ms. Bam, you've been watching my videos. If you're in California, just Google or go on ChatGPT and find out. It's something called like the Abused Foster Child Fund. There's something like that. You can do some research. You can find the name. Once you find the name, you go to their website. You get the application. You fill it out. You and your attorney hopefully fill it out, and you send it in. Ms. Bam, I hope that answers your question. Ms. Bam, although we didn't talk about that today, I talked about that on another show and other videos. So everyone, just to bring you up to speed, if you have a child who's a foster child and that child is abused in foster care, and Ms. Bam, it doesn't have to be sexually abused. It could be physically abused, emotionally or psychologically abused. You can make a claim against that fund, and either you can bring that part of your lawsuit, or they can just accept or deny your claim. But if you win your lawsuit, of course, the fund will have to pay. It's like insurance for foster children, but you just have to know that you have to make that claim, when and how to make that claim. So I don't know if most people don't know that when their kid goes into foster care, even with a relative, there's insurance out there for that foster kid if that foster kid gets injured. All right. VJ on YouTube says, I'm having a problem obtaining an attorney to represent me as a father since they took my daughter from the hospital, which her mother took her with no exigent circumstances in Georgia. 5-1 continuance date. VJ, you need to go on Google and for your area in Georgia, search juvenile dependency defense lawyer, search CPS defense lawyer, and believe me, you will find lawyers coming up in your area and in your state who can help you. If you need any more information, VJ, go ahead and call me, and I may be able to help you find someone. I recently, and I don't think I've ever done this, but recently someone contacted me from another state, and they said, I can't afford to hire you, but I want to hire you to help me find and interview the best CPS lawyer in my area. And I said, well, I can do that, but that's going to take me, a couple of hours of time to do that over maybe 3 or 4 days. And she said, well, I want to pay you and we will make the calls together. And I was kind of surprised, but I agreed to it. So now we're making calls together and interviewing people together, trying to find the best CPS lawyer for her and her state. And I think it was she was someplace in Pennsylvania. Okay, Margaret King on YouTube. The judge was elevated way off to my left. They had me facing only the counsel. Well, Margaret, you can, like I just told you, you can turn and shift your body to try to naturally include the judge in your testimony and in your conversation. Okay, Ms. Bam on YouTube, can you jail or prison the foster parent that sexually abused your child in foster care? Well, the answer is you can't, but the county or the state can. And many times I've heard over the years about foster parents being criminally prosecuted for abuse of a foster child. So yes, they can go to jail. So you got to make the police report. All right. Margaret on YouTube says, I completely agree. They did this on purpose. The judge is not included whatsoever. I could barely see him from the side of my eye. Yeah, that's a trick. That's a kind of a psychological trick. Sometimes that's played on you as a witness who doesn't know that they should be including the judge. All right, VJ from YouTube. I am unable to get any police reports or court documents or medical reports as a father who is viewed as a witness only and not a party without missing any visitation in 3 years. Well, VJ, I don't know what state you are and if the laws are different than California. That would be completely different from what I know. If you are the father and have been found to be a father, you're a party to the case, period, end of story. And as a party, you're entitled to the police reports, the court documents, and the medical reports. So how else are you going to win your case, get your child back in your custody? I did speak to someone a couple of weeks ago in a California county who told me that the social worker knew he was the father, but never told him to come to court. And so he was wondering why he couldn't get custody of his child, why the social worker didn't want him to court. I said, I don't know why the social worker doesn't want you. Obviously, she wants the kid to remain in foster care. But as the father, you have rights. So I told him, you're going to have to get an attorney or show up in court and ask for an attorney to be appointed to you so that you can make your motions and present evidence and having the child placed with you. Okay, Kelsey. This is Kelsey Oliver on YouTube. They're keeping my baby away from, I guess, me, even after the safety issues are no longer there because my baby's father is going to prison for 30 years. We're having mediation in June, which is far off. Kelsey, you need to talk to your lawyer or get a second opinion, because if what you're telling me is accurate, there's no reason to have the child away from you, unless they're trying to get the child placed in foster care or let the foster mother or parents adopt your child. Don't sleep on your rights. Be proactive. Brittany McCarrick from Facebook says, what are the honest benefits going pro per? I'm asking because I can't get anyone to do anything, request anything, or file motions. They just seem to be trying to keep the waters calm, not upset their fellow court family. Okay, because you're going on, but let me answer this. There are no benefits of you going pro per, in my opinion. Now, if your lawyer isn't doing what you think your lawyer should be doing, you need to make a motion if you're in California. It's called a Marsden motion, and I have a video on that on my YouTube channel, Brittany, how to make a Marsden motion to get a new court-appointed attorney. You can't just ask the judge, hey, I need a new court-appointed attorney because my attorney isn't doing his or her job. Okay, you got to make a formal motion. Some judges allow you to make that motion orally when you're in court, but you need to look at the video because there are things that you actually have to prove and say under oath to get a new court-appointed attorney. Brittany goes on to say, I have so much due process violations, misconduct, lies, lack of evidence, abuse of power. I've gone through 3 public defenders because I lost it. Because I continue to something them how they are ineffective counsel because they choose not to read the case file, but when it comes up, it's them trying to, and then ellipses, nothing else. Well, let me tell you this. And I've told people this before, and they kind of are shocked. And this is what I'm going to tell you the law in California. May be the same or similar in your state, maybe not. When you are given a court-appointed attorney, the law actually says, and I'll paraphrase, you're not entitled to Johnny Cochran. You just think you're entitled to Johnny Cochran. And that's not accurate. You're entitled to a warm body who generally knows the law and can generally help you. Are they required to do everything in their power to help you get your children back? You would think so, but no, that's not it. And remember one thing, we're living in America, okay? There are good things and there are bad things about living here. I'd say it's the greatest country in the world, but there's pros and cons to everything. And in America, there's a rule generally, and that rule is you get what you pay for. So please, if you get a court appointed attorney, don't expect you're going to have Johnny Cochran. Just being honest. All right, VJ from YouTube says Native American heritage validated in my maternal, including my daughter. Okay, then if it's been verified, you and your tribe should be stepping forward so that the ICWA laws apply. And under ICWA, it's very hard for the social worker to keep the child away from you if you're Native American. There's something called Indian Child Welfare Act. It's a federal law that has to be applied to all Indian cases. Talk to your attorney about that. Miss Bam on YouTube says, how can I know how my child is after months of not letting them see him? Okay, Miss Bam, first of all, I'm going to ask you, that's almost impossible for them not to let you see your child because there's so many things, safety precautions that can be done no matter who you are or what you've done in order to see your child. You can request a report from the social worker. I do it through your attorney and I do it in writing. VJ says, the judge stated in the court, quote unquote, stop it. There would be none of that. Nothing will be provided to me in writing. Okay, VJ, you got to tell me a little bit more. I don't understand what all of that means. It's one of those situations. Either you got to give me a clear explanation or I'm not sure what you're talking about. And if you want to, if it's too much to type, call me, 888-888-6582. Let's talk about it. All right, here's the last question for the day. Ms. Bam says, can you please call the parents and the children you have won for to come to motivate us in your channel, please? Okay, that's fair enough. I'm going to court later on this morning, and I won the big trial for this client, and we're closing her case today, hopefully. 7 children, can you imagine? And it was kind of a knockdown, drag-out fight during the trial, which we eventually won. And today they're supposed to be closing the case. I'll ask her. If she'll come on. Today's Friday. I'll ask her if she'll come on tomorrow. But yeah, I'll start having people come on that we've won for. That's a very good suggestion, Ms. Bam. Very good. All right. VJ says, I'll call you later. Thank you. Excellent. Margaret says, wow, 7. They are so blessed to have you in their lives. Thank you. All right. All righty, folks. Stay safe. Have a good day, and we'll see everyone tomorrow, 6:30 a.m. Pacific Standard Time for more office hours.
I'd like to thank Mr. Davis from the bottom of my heart. I'm going to cry. Without Mr. Davis, I wouldn't be back with my baby. I wouldn't be able to put my baby down at night. Without Mr. Davis, I wouldn't have been able to fight CPS. I wouldn't have known what to do and where to go. And if you're in the situation and if you don't know who to turn to or where to go, you need to call Mr. Davis. And you will definitely get the help that you need. Thank you, Mr. Davis.